Well, it's finally happened. The Supreme Court has finally done it. It's finally gotten around to doing what I've always thought it should do and recognize that the Equal Protection Clause of the 14th Amendment requires American governments, federal, state, and local, to refrain from discriminating against same-sex couples in the field of marriage and all of the legal benefits and privileges that go with that. So first, let me say I'd like to join all of the members of the LGBT community in celebrating this landmark decision and this historic day. This truly is a great victory for the cause of equality and for the cause of justice generally in our society. So way to go. It's good to see the United States catch up with most of the rest of the Western world in this particular domain. However, I would also like to sound a mildly cautionary note. I remember several years ago, while I was still in law school, I argued that while the Supreme Court should recognize that American governments have a constitutional duty to treat same-sex and opposite-sex couples equally, and while I anticipated that the Supreme Court probably would take that tack once a case involving that issue landed in front of it, I also said that the fight might not be over at that point. The fight might not be over because if the Supreme Court should essentially impose same-sex marriage on the whole country all at once, then that might provoke a certain political backlash, and it might re-energize the opponents of marriage equality and prompt them to fight back against the ruling any way they can, including proposals for an amendment to the U.S. Constitution, either to ban same-sex marriage or at the very least to overturn this particular Supreme Court ruling and simply leave the question to the states. Now, given the changes that have taken place in American culture and society over the past decade or so, I suspect that if there is such an effort, it will probably tackle that latter, more modest goal of simply amending the U.S. Constitution to leave the question of the definition of marriage to the states, rather than trying to ban same-sex marriage altogether through a constitutional amendment, as George W. Bush proposed in 2004, for example. I imagine that'll be the case simply because so many Americans have come to agree with the principle of marriage equality, and those who remain staunchly opposed to it have become so concentrated in the Bible Belt that I think supporters of such a constitutional amendment would recognize that trying to ban same-sex marriage through the Constitution simply would be guaranteed to fail. It would be biting off more than they could chew. So they would probably go for the somewhat more modest and less unrealistic objective of simply allowing various state governments to recognize or not recognize same-sex marriage based on the wishes of a majority of their residents. Now, I don't think that effort would necessarily succeed, but now that the Supreme Court has ruled to require same-sex marriage across the whole country all at once, I think that we can expect opponents of same-sex marriage to at least mount those efforts. And so, I'm not sure that the fat lady has sung yet. Hopefully she has. And there's a very good chance that she has. I mean, given, like I said, American public opinion on this issue has changed so drastically just in the past decade that I do think it's likely that these efforts will fail. But that doesn't mean that the efforts won't be mounted, nor does it mean that we won't have to, supporters of marriage equality won't have to expend some energy fighting these proposals and putting them to bed. So that's just the note I wanted to sound. In one of my earliest videos last fall, I suspected that my earlier pessimism on that issue might be unfounded. A few years ago, when I was in law school, I feared that the political backlash against a ruling from the Supreme Court, just such as the one the court has handed down today, that the backlash actually might stand a chance of success. Given everything that's happened since then, I no longer harbor that fear, but that still doesn't mean that we won't have to, put some elbow grease into the efforts to resist that backlash against the Supreme Court's ruling. That is basically the only cautionary note that I would sound at this present time. Other than that, I think that today is a good day. I think it's a great day for the cause of equality and for the cause of justice for the LGBT community. And it's a great day for the Constitution. I understand a lot of opponents of same-sex marriage really struggle with the idea that the Constitution can protect same-sex marriage even though it doesn't mention marriage or sexual orientation at all. But what people have to understand is it's not about marriage per se when it comes to the Constitution. I remember a former co-worker of mine saying to me that he doesn't think that the Constitution protects a right to marry. I agree. The Constitution doesn't protect a right to marry. What it protects is what I view as a constitutional entitlement to the equal protection of the laws. It means that since marriage is a matter of such fundamental importance in society at large, the government cannot discriminate between same-sex couples and opposite-sex couples, without a damn good reason, essentially. And that reason just doesn't exist. Scientific research has shown that homosexuality is not a choice. While the scientific jury is still out as to the causes of it, there's a reigning consensus, and a credible one if you ask me, that it's not a choice. It's not something people choose or that they can change, and it's not intrinsically harmful to anyone. Therefore, it's not the kind of personal characteristic on which people should be discriminated against. They shouldn't be judged based on that, and their access to key social and legal institutions such as marriage should not be determined on that basis. Now, for those who point out that the framers of the 14th Amendment and the Equal Protection Clause could never have imagined that it would one day be used to bring about same-sex marriage across the land, remember, the principle is equal protection. If the government were to take a libertarian position and stop licensing marriages altogether, gay or straight, then that would also satisfy the Equal Protection Clause, because the two communities, straight and gay, would still be treated equally. They would both be denied access to an institution of legal marriage, government-licensed marriage. And when it comes to the question of, the meaning of the Constitution changing over time, I don't think that the Constitution's meaning has changed over time. That equal protection principle has been there since 1868. However, when it comes to homosexuality, I think the fact of the matter is, in the 19th century, in 1868, when the Equal Protection Clause was first drafted and enacted, at that time, people in society didn't know that homosexuality was not a choice. They thought of it as just a degenerate lifestyle that people chose and for which they could justly be punished. But in the past 30 or 40 years, society has come to the realization, based on scientific research and anecdotal evidence, that homosexuality is not a choice, and that it's not intrinsically harmful to anyone, certainly not to society at large, and therefore there is no solid, sound justification for denying same-sex couples access to the marriage franchise. There just isn't any. So it's not that the Constitution has metamorphosized spontaneously over the past century and a half to include a right that wasn't originally contemplated by its authors, its framers. Rather, the facts of which we're aware in society have become clearer to us. We have a better understanding of what homosexuality is nowadays, and given that we have that better understanding, when you combine those factual understandings and that factual knowledge with the ingredient of the equal protection principle as laid out in the 14th Amendment, it leads to a different, and I would say more just result today than what would have prevailed in the past, based on past understandings, outdated understandings of what homosexuality is. So for those reasons, I think that this decision is entirely the right one, and ultimately I think this cause will prevail if it hasn't prevailed already. There probably will be some pushback, and we'll have to put some effort into resisting that pushback, but ultimately the cause of marriage equality will prevail. And I'm entirely happy about that. It's a great day. Let's celebrate. Sayonara.